This week, the Federal Trade Commission issued a final ruling to promote competition by banning non-competes nationwide. This ruling was based on protecting employees' abilities to change jobs, start businesses, and ultimately do what's best for them. Arguments were made that non compete clauses reduce wages, slow innovation, suppress new ideas, and even go so far as to prohibit new businesses from starting. The Federal Trade Commission estimates that something like more than 8,500 businesses would be created in the first year, status post non competes being eliminated. Predictions associated with the ban include up to 3% new business formation each year, increased earnings for workers by up to $500 per year, and interestingly, lower costs of healthcare by almost $200 billion. And last but not least, to drive innovation. So it's going to promote the reduction of healthcare costs, increase in new business formation, an increase in innovation. They're expecting anywhere from 15 to 30,000 more patents each year because people aren't felt like they're beholden or trapped at their employers. Ultimately, it's going to lead to growth, it's going to lead to innovation, and it's going to lead to up to 500 billion with a B dollars in increased wages for workers over the next decade. A little refresher for you on non competes. They are widespread, particularly in healthcare, and in the last 10 years have really started to affect advanced practice providers alongside physicians. Non competes prevent workers from taking a new job, starting a new business, opening their own practice, or changing hospitals, practices, sometimes even specialties or departments or employers. The specifics of the non compete tend to differ widely depending on the area of the country that you're in, your particular practice setting, the specialty that you work in, and the type of employer you have. Typically, they include a time frame, a specific distance or radius of prohibition, and specific restrictions in terms of specialty or setting. Currently, nearly 1 in 5 workers in America are subject to non competes. So, this Federal Trade Commission ruling will affect an estimated 30 million workers. So, what does this mean for you if you're listening to this and you press play because you have a non compete? Existing non competes for the majority of workers will no longer be enforceable after the ruling is put into effect. However, existing non competes for senior executives, which represents less than 1% of the workforce, can remain in force under the rule, but employers are banned from entering into or attempting to enforce any new non competes, whether at that senior executive level or not. Specifically, and I think this is super important to those of you who are in administration or on the higher end of income earnings, the final ruling from the Federal Trade Commission defines the term senior executive to refer to any workers earning more than $151,164 who are in a policy making position. If you are an advanced practice leader, if you are the head of a department, if you are a chief executive, if you are a VP of something, chances are you are above that income limit and also you are in a policy making position. So be sure to investigate whether this new ruling affects you or not. Though the Federal Trade Commission recognized that it doesn't have jurisdiction over nonprofit entities, which is many hospitals and many healthcare systems, it reserves the right to evaluate an entity's nonprofit status, which would include a significant portion of the over 6,000 hospitals in the US. So, this voting for the ban happened on April 23rd. So, the agency noted that some portion of the 58% of hospitals that claim tax exempt status as nonprofits and the 19% of hospitals that identified as state or local government hospitals aren't necessarily subject to this rule. So if you have a non-compete and you happen to work for a nonprofit or a federal or local, from a state government standpoint, hospital, stay tuned for how this non-compete ban might affect you. The final rule, when it's put into place, would have significant implications for the healthcare industry at large. And some executives have called this a double whammy against hospitals. I am here to tell you that sometimes when the executives are complaining about something working against the hospital, it will make it better for the consumer or better for the employee in this standpoint. So, your employer should provide you notice if you have a non compete that your non compete agreement will not be enforced against you in the future. The non compete ban passed by a vote of 3-2, and it reads a lengthy 570 pages long. The bottom line for you is that non competes will no longer be enforceable or entered into across the United States. Again, keeping in mind those caveats about executive positions, nonprofit, and government hospitals or employers. The regulation's effective date will be 120 days after the Federal Register publication, not after their public announcement. So stay tuned for the sort of ratification and the date that this will become effective and applicable to you and your practice in your area. It's good to know your state and federal laws, and this is something that potentially could help you to increase some career mobility in terms of where you can go, what you can do, and that you're no longer limited by time or geography relative to your current position and non-compete. Thank you, as always, for tuning in to another little behind the scenes episode of The PA is In. We'll catch you next time. This PA is out.